Welcome, Kate Brown de Wecher. Thank you very much to be with us this afternoon or this night, depending on you are and on we are. And you know, uh, you know the purpose of this interview. We are talking with our young practitioners in Brazil, and we have young practitioners making this interview. This is their program and their idea, and I am only the old guy here in order to coordinate. And DLA Piper is a global law firm with lawyers located in more than 40 countries. And Kate is the global co-chair of international arbitration. She is in Mexico. She is not Mexican, of course. She is Australian, and she lives in Mexico. And she is a practitioner in international commercial arbitration, investment arbitration, energy, mining, oil and gas, and construction. She is involved with LCIA, IBA, ICDR, and UNCITRAL. And Kate has been named on one of the top 100 female lawyers in Latin America by Latin Vax 2020, which is something very important to us. So I would like to, we'd like to make this interview a very informal one. So the first one to interview is Fabi. The floor is yours.
Thank you, Professor Carmona. Hello, Kate. Thank you for being here with us. It's a great pleasure. And so I'll go straight to my questions. I have two questions regarding your personal experience. So the first one is, when and how did you start working with arbitration?
May I start by first saying thank you so much for the invitation. It's a privilege to be here, and thank you very much to all the organizers. Answering when gives away a little bit, but I will answer you truthfully. I had my first experience in international arbitration being involved as a student in the 2001 Vismut Court in Vienna. I represented the University of Queensland, and incidentally, it is where I met my now husband, the Mexican, Rodolfo, who was representing the Panamericana University. So there's some significant Vismut history there. From that experience, I was so fascinated with this area of practice that I really looked for and I actively campaigned for internships in practice groups in law firms that had a very, well-reputed practice in this particular area. So I did internships at Shearman and Sterling in Paris, in Freshfields in both Paris and London. And then I did an internship also with the International Chamber of Commerce in Paris. And all of those, some of them were paid, some of them were unpaid. It wasn't easy living sometimes in a big city on an unpaid internship. But I did think that it was definitely an important part of building my CV and showing my interest in this area and developing experience.
That's amazing. It's so great to hear your story, your history a little bit, and how you're connected to Vismut. I think most of us did some kind of competition, so it's awesome. And so my second question is, you are widely recognized for your experience in handling complex and high-profile disputes in the energy and infrastructure sectors, especially, or for example. And what are your views on counsel specialization in international arbitration?
So I certainly think that counsel specialization and having the ability to, or at least to put together a team of people that have the right sector experience, as well as perhaps the right geographic or linguistic experience, and then also the arbitration experience, I think that's really important. And the fact is, clients demand it. Our pharmaceutical clients, for example, want a lawyer, an arbitration lawyer, who they can talk intelligently to about biochemistry. Or our tech clients need us to be able to understand and then be able to explain to a tribunal what the patent history attached to their technology means and how it developed over time. And so in order to do that, we need to have some patent expertise. If you've got an infrastructure project with delay or disruption issues, then you really do need to have someone who knows what a delay and disruption analysis looks like and how the damages that flow from those incidents on a construction project flow then into a damages analysis. And so I do think that a level of specialization is very important. That said, not all of that specialization necessarily has to reside in an individual. If you can put together the right team and present those characteristics as team characteristics, provided your team can work seamlessly, that can do the same job. So the other thing I would make sure I emphasize is that a really good dispute resolution lawyer studies the facts and the technical aspects of the case with a level of detail and devotion that they actually become an expert on the matter very, very quickly. That's actually one of the very important skills in this area of practice. It's also part of the fun, because one day you can become a turbine expert and the next day you can become an expert on, COVID vaccines. So I think that's what adds a lot of interest to our area of practice, provided you're willing to put in the time and effort to become that expert. That means that you become the person in the room, in the hearing, that the tribunal looks to for the answers, looks to be the person who explains to them what really went on. So having that ability to immerse yourself in the case is really important.
Thank you so much. It's great to have you sharing all of this with us. Thank you.
It's lovely to speak to you, Fabiana.
So two very important tips. The first one is, if you want to get married, go to Wismut. And the second one is, it is true. Sometimes some engineer get amazed with me and some companions and other arbitrators because we can't speak their language when it refers to construction. Because working with construction, have been working with construction during this 30 or 40 years, give you some expertise and some knowledge about the construction itself. So it's very important, because you can talk with the parties and you can talk with the experts, and you can understand, you can fully understand the case. So you are absolutely right. If you keep studying the facts, you will become an expert, and this is paramount. This is very important. Okay, next one is Gustavo. The floor is yours, Gustavo.
Thank you, Professor Carmona. Thank you, Kate, for being here with us. It's great pleasure, like Fabi said, and an honor to us for sure. I will turn now my questions to a very important and sensitive issue, which is diversity. So the first question is the following: did you face difficulties in your career being a female? And another question that I would like to add to this first one is, what was your role model, if any, in pursuing your career?
I agree it can be a difficult issue, but you're absolutely right. It's one of the most important. Thank you, Gustavo. I had very strong, and I will say mainly male, mentors at various points in my early career. I think at every law firm that I worked at early on, I can identify a particular mentor who was an expert in arbitration and who really gave me opportunities and dedicated time to my development. For example, allowed me the opportunity to work as a secretary to the arbitral tribunal, to really see how the inner workings of the tribunal occurred, or gave me opportunities to do first drafts of documents, or eventually to participate in my first oral argument. Those mentors, those people who really offer you opportunities at any time, meant that I don't think I ever felt any disadvantage professionally from the fact that I was a woman. I do think that I benefited a lot from two things. First of all, growing up in an environment in Australia where, honestly, from the high school that I went to the university that I went to the professional experiences I had, I never felt that pressure. Now that is, I think, slightly different from the experiences that young Mexican female lawyers can have sometimes in the professional environment. I don't think they necessarily have grown up, at least at the current generational level of young lawyers entering law firms. They still don't see enough female role models. They still don't see enough female partners or other people in executive positions. And I think they still wonder whether this is a career that is easy or one that they can access. And on the point of role models, I do think that that is key. I think if you can see someone who is a little bit like you, who is doing well in this area, then that is a huge motivational factor, and it tells you that it's possible. I was very fortunate because my mother was a lawyer. She was a partner in a law firm in Australia, a big national law firm, now international. It's called Minter Ellison. And, I grew up with knowing that she, first of all, really enjoyed her work. She actually had a science background. She worked in biotechnology, protecting intellectual property interests of scientists and universities. She was passionate about her work. So I had the benefit of seeing a full-time working mom, managing it all, sometimes not managing it all, but who was really motivated by her career. So I grew up believing that was entirely normal. And so I believe that the self-belief aspect of this is really important. The more role models we create, the more people have professionals they can look up to that look a little bit like them, the easier we make the path.
That's awesome, Kate. Thank you very much. It's interesting to know that your mom is your role model. If I were in your position, I would say that my father, who's a lawyer, he's my role model too. He's not in arbitration, so now the next question. We've seen the international arbitration community, particularly, a movement towards promoting diversity, which is great and again very important. Institutions such as Rio, for example, and Arbitral Women are working hard to promote diversity. And so, in your opinion, what would you say that is important, and how can we increase diversity in international arbitration? And by diversity, I mean here racial diversity, gender diversity, ethnic, like the broad sense of the term.
I think the number one thing we can do is to take really conscious decisions to be inclusive and promote diversity at every possible opportunity, at every juncture. So if you're looking at potential recruits for a law firm, if you're looking at the people you are interviewing, it's important to see them as a group and say, am I taking the effort to find and give opportunities to a diverse range of people? If you're not, you're doing something wrong, because we all know that there are very talented, diverse candidates out there. So if we're not finding them, then that is on us. Secondly, I think when you are, for example, choosing an arbitrator, you have to ask yourself the same question. Am I looking at and giving opportunities to a diverse range of candidates? If I've got 5, I should be looking at 5 diverse candidates. The same thing when you are staffing a particular matter within a law firm. If I'm proposing a group of people in a pitch to a client, I have to ask myself, am I putting forward a team which is sufficiently diverse to properly service this client? And the truth is that today it's not even an option. Clients demand it. If you give them a non-diverse team that's going to be working on their case, some of them simply walk away. Some of them actually do give the opportunity to the firm to correct their conduct, but they tell you that that's not on. And some clients require, as a part of their engagement letter, that you report to them the number of hours and tasks that are being assigned to each of the candidates, so that they can see that it's not that you've put a diverse slate of people in front of them at the beginning and then not given those people equal amounts of work to do. So I would say, law firms are probably behind in terms of adopting these practices. The industry is requiring it of us. And what we need to be doing is asking ourselves the question at every single opportunity: are we putting forward, or are we examining diverse candidates? I think also when we look at things like mentoring, when we look at things like the Vismoot, when we look at some of those entry points into the practice, we have to make sure that at that point we're also encouraging a diverse range of young entrants, because of course if you don't have them at the early stages, then they're not going to be there at the more senior levels of their career either.
Perfect, Kate. Thank you so much. Very interesting.
Kate, you mentioned incidentally the importance of serving as secretary of the arbitral tribunal. And I keep insisting with my students about the importance of working with arbitrators and having a look on arbitration from the inside perspective. I would like you to elaborate a little more the importance of serving as secretary of the tribunal to our students, please.
Absolutely. I think there are two types of experience that are really important as a junior practitioner. I think if you can get experience as a secretary to a tribunal, I think most rules now do call for anyone assisting you as an arbitrator to be disclosed, and I think that is a good practice. But it is an invaluable way for you to see potentially a range of different matters. If you're assisting a single arbitrator on a range of matters, you can see an LCIA case, an ICC case, an LCDR case, a local chamber of commerce case. You can look at how different procedures play out. And I think having the ability to see what happens if one of the parties asks for interim measures, how does that play out in a case? What about another case where you don't have a participating respondent? How does the arbitrator handle that scenario? And I think where, as a practicing lawyer in an arbitration group in a law firm, your experiences is a little bit limited to the cases that your law firm is seeing. If you can get additional experience across a range of cases, working as a secretary to a tribunal, I think it gives you a much broader point of observation, if you like, across different types of cases. And I would say the same thing for working at an institution, even if it is, as I did, a little unpaid internship. You get to see a broad number of cases and very different things happening on each cases. And sometimes the institutions see things that the rest of us don't. And I think you get some really interesting insights, both into what is good practice as a lawyer representing a party in a case, but also what is good practice in terms of acting as an arbitrator, and what types of arguments and proofs do arbitrators find persuasive? What styles of cross-examination do arbitrators find persuasive? And if you have that experience, that can improve your own practice.
Couldn't agree more. Yeah, perfect. So now is João, a navigating coacher. The floor is yours.
Thank you, Professor Carmona. And hi, Kate. It's so good to have you today with us.
Likewise.
And to work with you at DLA Piper as well. So being in a global law firm like DLA, you face the culture and several different cultures as an issue. So my question is, in your experience as a counsel, how do you navigate different jurisdictions and cultures in your arbitration strategy? How do you handle and how do you see this issue, or is this an issue in international arbitration?
I always try to approach cultural differences and differences arising from practicing in different jurisdictions with curiosity. I think that's the best word for it, as an opportunity to be willing to learn. And I think you have to never dismiss the differences across borders and different cultures, and never underestimate how they will affect behavior, whether it's of opposing counsel or whether it's of a witness giving testimony, or whether it's as an arbitrator, how a particular fact or argument will sit with that person. I was recently involved in a matter where we had to cross-examine a number of Japanese witnesses, a very different culture from either Mexico or Australia. And what we decided to do was to work with a native Japanese person who had a good understanding of the case, who helped us, first of all, formulate all of our cross-examination questions. And then we actually practiced all our cross-examination on that person, using the documents we plan to use to see whether there would be any nuances that we were missing. And you would be surprised the number of times that that person suggested a reformulation of the question so that we would encourage perhaps a more cooperative answer, or where there were likely to be translation issues. So where the way that I was formulating the question in English could lead to either a lack of clarity or a very complicated translation in Japanese. And so that person actually recommended ways in which we could change the formulation of the question so that it would be likely to elicit a clearer answer. So I think that's just one example of how it affects your practice. I do think also that working in this area gives you a very privileged opportunity to learn about different cultures. You travel quite a lot, you do visit different countries. Those countries can have very different cultures, religions, and customs to what you're used to. Even making sure before you go to a meeting with a client or opposing counsel, or you examine a witness, even making sure that you are pronouncing the person's name correctly as a gesture of respect can be a very important element to incorporate into your practice. There's nothing worse than starting out your interaction with someone by mispronouncing their name. I think it shows a lack of effort. So little nuances like that, respecting the differences between different cultures and really trying to learn about them, I think is one of the more fascinating aspects of this practice.
Yeah, I couldn't agree more. I just remember now a fact during my LLM, because we were like a group of 10 Brazilians, and many people from different countries used to ask, oh, you Brazilians really like to hug each other, you are like really friendly. So for sure, the culture aspect, it's really important, and mainly in international arbitration. One additional question under this topic would be a comparison between investment arbitration and international commercial arbitration. Because in Brazil, as you may know, we are not quite used to investment arbitration. So, and you are quite an expert in this topic. So what do investment arbitration cases demand, for instance, from arbitrators that is different from acting in commercial arbitrations?
So I think I would start out by observing that many of the skills are equally applicable to both. So I think some of the aspects that we already talked about, attention to detail, really becoming an expert on the area, being very thorough, and as an arbitrator, I think all of those skills are very transferable one to the other. But certainly there are what I would say public international law concepts that come into play in investor-state arbitration that are obviously absent from your normal commercial dispute. So those, I think, require a certain level of study and familiarity. And I would recommend to anyone who is interested in practicing an investor-state arbitration at some point, if there are public international law subjects available at your university, then that is something that is worth studying, because there are concepts that are very unique. If you think about how to interpret treaties, what are the interpretation rules for treaties? Are they the same as under national law for contracts? The answer is no. Secondly, state responsibility. In what circumstances are the behaviors of an individual or a company or a state or an entity or a governor actually able to be attributable to the nation, to the central government, in terms of making it responsible for the conduct of that person? And if that conduct was wrongful, making that a breach of that country's treaty obligations. Learning how state practice and customary international law evolve, how does international law evolve? One of the ways is to look at how states behave, state practice, knowing what the sources of customary international law are and what to look at, and then to be able to draw upon them to convince a tribunal that this particular rule should be applied in this circumstance. Those are really important skills, and I think they do require a level, as I said, of study or experience. It's also helpful to know where some of those concepts have come from. So some concepts that you see in a bilateral investment treaty, for example, where you see the investor having certain guarantees that their investment will receive fair and equitable treatment. Now that standard actually has a lot of content to it, and there's a lot of law and history in what the content of that standard is. It doesn't necessarily just mean that they have to be treated just fairly. There's a lot of meaning behind the words. Similarly, concepts like MFN, most favored nation, those actually have a history of coming from international trade law, WTO law. And so knowing where some of these concepts came from and how they've evolved, I think is a really important part of being an investment treaty arbitrator.
Thank you, Kate. Professor Carmona, I give you the floor.
Fabi, your turn. Arbitration in Brazil.
Thank you. So yes, we love to learn about international arbitration and investment arbitration, but we are Brazilians, so we also love to know what is your experience with Brazil. So have you ever participated in an arbitration involving Brazilian parties or Brazilian law?
So I've been involved in disputes involving a Brazilian party, and also in one instance, in a case where one of the contracts that was in dispute was governed by Brazilian law. But I've never been involved in an arbitration that's been seated in Brazil. So I've got that on my to-do list. I think the international arbitration community in Brazil is certainly strong and thriving. I think commercial parties, and we know this from our own client base, regularly and confidently accept arbitration as a dispute resolution mechanism. And I do think that one of the tests for whether a country is a healthy international arbitration destination is when it has strong local institutions as well. And I think, for example, the Brazil-Canada Chamber of Commerce or the Brazilian Center of Mediation and Arbitration, both of those have, really strong international reputations, and they are institutions that we regularly recommend to our clients as perfectly acceptable sources of rules for the resolution of their disputes. So those, I think, are the hallmarks of a solid arbitration destination. And I think that probably the Brazilian international arbitration profession is to be, congratulated for having created such a encouraging environment.
Thank you. And well, we do have one of the main persons that collaborated to this. So I'll give the floor to Professor Carmona.
Kate, here in Brazil, we say that São Paulo wants to be new Miami in international arbitration because you want to be the center for arbitration of Latin America. And we hope so. We hope we have good centers and very important centers, international centers, as you said. And we hope we will become the new Miami in this century, I suppose. I hope so. Okay, so now we're going to touch an argument that arbitrators hate, which is annulment of awards. Gustavo.
Yeah, so I got the difficult part here. But yeah, in the post-award stage, we oftentimes talk about annulment of arbitral awards. And Kate, what's your view on how can counsel and arbitrators alike prevent awards from becoming targets of frivolous requests for annulment?
So I really liked this question when I saw that you guys might ask it. My first reaction is that a client doesn't usually try to annul or set aside an arbitral award unless a lawyer has told them that it's a good idea. So I think occasionally you can get applications to set aside or annul awards because the party is taking a position of principle. They feel that they cannot not do it. But by far the majority of instances where you have set aside applications or annulment applications that really don't merit it, it's because a lawyer has told a client that it's a good idea. So I think there we have what I would say there's 3 areas of opportunity. Number one is to continue what I think has already been a very concerted education effort to make sure that lawyers practicing in this area, as well as the clients involved, understand the conditions upon which a set aside or annulment application should be made and the very high bar that has to be met in order for them to be successful. Now, I think I can certainly draw upon some of my experience in Mexico, where occasionally we come across a set-aside application that is brought by a very well-reputed litigation boutique that may not have the depth of experience in international arbitration or the level of experience with the New York Convention to understand exactly how difficult all of the standards are that would need to be established. So I think there's still a level of education that can be done with our colleagues, as well as the judiciary, of course. Number 2 is I think we could use more frequently the costs of the litigation as a way of dissuading parties from bringing frivolous applications to set aside or annul. I know that in many jurisdictions, like my own home jurisdiction, Australia, we do have a rule that costs follow the event, or loser pays. Now that is a very effective stick to use against a litigating party to say, well, if the claim you're bringing really is not meritorious and the other side very clearly won the day, you don't even have to show that it was frivolous. You just have to say that a good legal mind would have reached the conclusion that this would probably not prevail, and therefore you have to pay the other person's costs of defending this proceeding. Now, there is usually a measure of what costs are reasonable, so not necessarily 100% reimbursement, but that is a very effective tool. And we are seeing that be employed even in jurisdictions where that's not normally the case. So there's certainly case law in New York where usually each side pays their own legal costs, but where a judge said, this application to set aside this award was so frivolous that you, the law firm, are going to pay the costs of the other side. So it wasn't even the client who had to pay them. The law firm was ordered to pay them. Why? That brings me back to my first point, because a lawyer told them that it was a good idea to bring the case. The third opportunity, I think, is that where you have a party bringing an application to set aside where they are, that should never be brought. It can often be in situations where the party simply cannot live with that outcome, cannot live with it, impossible. Now, those are the cases where actually early settlement would have been the right outcome. So I think working hard to identify those cases where there's no way that the counterparty could possibly live with the outcome of this case, and therefore saying, well, they should have a special interest in not letting it get to an outcome, and working very hard to settle the case early, working out what those motives are. I think those are 3 things that we could all do better to make sure that we see fewer of the frivolous set-aside and annulment applications.
Thank you, Kate. This is also very interesting. We have to have this mindset of not trying to seek frivolous annulments of arbitral awards, and also we have to have a strong judiciary and very clear rules, right, to avoid this kind of temptations sometimes. Professor Carmona,
exactly.
The floor is yours again. Thank you.
Yeah, but here there's a criticism from the Brazilian way, because in our procedural law, we have the procedural bad faith, which is something that it's a tool that the judge can apply against the party, not against the lawyer, but against the party that try to manage a frivolous case. But the courts hesitate in doing this and applying and using this tool. And this is a problem because, of course, they recognize it is completely out of sense to manage this case. They recognize it in the reasoning of their decision, but they do not apply any penalty. So it's a pity. So it's a problem of education, as you said, and this is very, very important. But education to the lawyers, to the parties, and to the judges also, because they have to refrain this behavior, and they do not have the courage to face this problem, which is a real big problem in Brazil. And this takes us to the next topic, which is related to the challenges of arbitration. From your point of view, what are the most important challenge we are going to face in this moment?
Also a very interesting question. I think perhaps the major challenges, we could separate for a moment the investor state cases from the commercial cases. I do think in the investor state arbitration space, we are in a situation where a number of the participants, particularly states, are questioning whether the system of having ad hoc arbitrators appointed private individuals to decide these kinds of disputes is the best system. We are seeing a push potentially for there to be an investment court established where you would have more of a system of judges to decide these disputes. And the reasons why those initiatives have come up, I think, are very broad ranging, but partially related to, I think, some inconsistency in some decisions where then participants in arbitration are saying, well, if we had a group of standing judges, then you'd assume you'd get more consistency. There's also an idea of the fact that you've got private individuals who sometimes also act as counsel in arbitrators, then putting on their arbitrator hat and having these dual roles, and whether that's something that's desirable. So you have various bodies looking at these issues, and I do think that we're going to see some changes. The UNCITRAL, the United Nations Commission on International Trade Law, has established a working group 3, which is looking specifically at these issues, and they're looking at a couple of different ways to address them. One is the issue of the investment court. And you also have UNCITRAL working together with ICSID on a code of conduct for adjudicators in investor state arbitration to try and address some of the concerns about the impartiality and independence of adjudicators in that area. So I think the code of conduct reached its 4th draft earlier in July, or so. We are seeing some significant movement to try and reassure, I think, those who are using the investor state arbitration system that it is a system that works. But that's definitely one of the challenges that goes to, I think, the legitimacy of this ad hoc system of arbitrators that we have. If we look at the commercial area, I actually think that the challenges there are shared with the investor state arbitration industry. That is, I think there will always be the issues of time and cost. I think you've seen a lot of arbitration institutions come out with recommendations about how to better manage the time and costs associated with arbitration. I do think that if parties are opting for arbitration as distinct from litigation before the national tribunals, I think they do want it to be faster and cheaper, and they can be very disappointed when it is not. I know that in our practice, we're seeing a lot of parties opt into expedited rules in their arbitration clauses, which provides for a cheaper and faster and more simple procedure, precisely because the main thing they want is to be able to get to the resolution of their commercial dispute faster and to have the costs associated with it be more predictable.
But Kate, don't you think that this system of the revolving door, or acting as with 2 hats, as you said, today being a lawyer and tomorrow being an arbitrator, don't you think it is good for arbitrating for arbitration, because my experience as a lawyer permits me to understand better your arguments and to know exactly your strategy during the procedure. So isn't this something very valuable to arbitration?
I completely agree with you in the commercial space. And I don't think that anyone is really too concerned about lawyers in commercial arbitration acting at the same time, representing their clients in an ICC or an LCIA case, and then being appointed as an arbitrator. And I do think that the crossover of that experience is very valuable, both for the lawyer and for their clients. So I don't want to confuse what I think is an absolutely normal and very valuable practice in the commercial sphere. I do think that in investor-state arbitration, there are some peculiarities of the system that make acting as a counsel as well as acting as an arbitrator potentially concurrently or simultaneously a little bit challenging. And I think if we look at what those challenges are, I think you probably agree with me that those are instances which would make you sort of do what I'm doing, furrow your brow. Number one is, what if it involves the same state party? So, or the same claimant even. So what, could you be acting in a matter where the same state party is respondent as an arbitrator, and then in a totally different unrelated case, be an arbitrator or be counsel in a matter for or against that country? Now, you may look at me and say, well, when would that even happen? Because surely your conflict rules would apply to mean that you can't be acting for and against the same entity. But remember, acting as an arbitrator under some rules, under some ethical rules, people see it as a neutral appointment. And so the question is, could you be acting as an arbitrator sitting in judgment upon a state at the same time that you're acting for or against them in a different matter? That's one instance. Or what if it involves the same treaty, or actually the interpretation of certain terms of that treaty or certain provisions of the treaty? If you are in one case deciding that as an adjudicator, you're deciding what fair and equitable treatment means in this treaty, but you're arguing that in another case. I mean, you could even take the extreme example. Would there be any temptation as an arbitrator to issue an award that would actually favor your client in the case where you're arguing as to the meaning of the same clause? So I do think that there are instances in investor-state arbitration where, because we're interpreting the same instruments, or because we're interpreting provisions within a treaty that may be very similar from one case to another, or sometimes because we're looking at the same measure. So where, for example, you've seen the cases in Spain where you had a lot of solar tariff related cases occur. What if you are asked to adjudicate on a case about those solar tariffs, but then also asked to argue one? Is that okay? So those I think are why that issue is particularly relevant in the investor-state arbitration space.
So would you support this idea of having an international court for investment cases rather than it would be better than arbitration?
I think it's a very intriguing idea, and it's one that has already been adopted to some extent by certain countries in their treaties. Europe has included it in its treaty with Canada, and I think with Vietnam as well. The fact that as between those two states, or Europe and the relevant state, they're actually going to create a court of arbitrators who can adjudicate the disputes under that treaty. I think it could be a way of addressing some of the concerns that have been raised. I think perhaps it would lead to additional consistency in decisions. I do think that it faces many challenges, and I do think we're some distance from it ever actually materializing. First of all, who's going to pay for it? Where is it going to be located? How are those judges going to be appointed? And when are all these states that can't agree on anything at the moment actually going to agree on all those things? So I do think that I know the conversation is ongoing. I do believe that there are very strong voices in the room in favor of it. I I think that even if it does come to fruition, it will be some time until it's implemented, and we will still have all these treaties out there that call for an ad hoc tribunal to be formed. So in order for this idea to take over, in order for an investment court to take over all of the disputes in this area, either all of those treaties will have to be amended, or there will have to be some kind of central convention that all of the state parties sign on to that has the effect of amending those conventions. So I think for now, while we can certainly look at that as an option, we also have to concentrate on making sure that the system that we currently have works the best it can.
Or we can think about The Hague too, something like this, an international court like The Hague, which is not that good, but especially for investment. But this is an idea. Okay, very interesting, this discussion. And now, João, it's your turn again.
Thank you, Professor Carmona. Kate, as young practitioners, and I would include Professor Carmona as well, but just a bit less younger than us, what would you say to a young arbitration practitioner who would like to be a really good arbitrator? What he or she must do to follow this path?
So I think I'd actually hark back to perhaps some of my earlier comments, which is that I think what I learned early in my career was the value of becoming the person in the room who knows the facts and the law the best. So if you really do the work and become that person on the case that knows everything inside out, who remembers that one document that is really important and that the others have overlooked, that becomes the person in the room that the tribunal looks to and trusts to give them the correct answer. There's nothing better when you're in a hearing room and the tribunal asks a question of opposing counsel and you see them fumbling through their papers and shuffling things around and looking for a document, and you can very discreetly say, Mr. President, members of the tribunal, I think the exhibit that opposing counsel is looking for is C25. It gives you a certain authority. So if you can become that person in the room, that I think means you are well on your way to becoming a really star practitioner. I think you also have to love both the written form of argumentative writing. So when you draft a brief, I think you have to have that kind of personality that really cares about the formulation of the sentences. Is what I am writing convincing? If you're writing it and it's hard to write, that's a sign that what you're writing isn't working, because the argument should flow and so that the reader will read it and it will make sense to them and be logical, but also hopefully pleasurable to read. Now, that may sound insane, but a well-written brief is one that an arbitrator can read easily, and actually they enjoy the writing. Someone has actually invested time in making sure that the way this is written makes it a pleasure to read. So I think you have to love that aspect of it. And then hopefully you also love the oral advocacy part. So I do encourage practitioners to invest in their own training in oral advocacy as well. There are many sort of training opportunities, and now there's a lot more, I would say, online training opportunities for you to practice, to get tips on how to do a good opening statement, how to do a good cross-examination. And so there's actually one that I'm personally involved in. It's called ROAP, which is the Remote Oral Advocacy Program, but there are many others. And because they're remote, they're very accessible. So I'd encourage everyone to invest in the development of those skills. So oral advocacy, written advocacy, and then, be the person who invests the time to know the record better than anybody else.
Those are really good tips, especially the one of Mr. President. Maybe the document that the opposing counsel is looking for, it's C11. and really good tips not only for the Vismut but also for real arbitration. So it's really good to know. Professor Carmona was telling me that he would like to ask some general questions, so I pass the floor to Professor Carmona.
Thank you. It's interesting what you said, Kate, about the petitions. I, as an arbitrator, keep receiving legal opinions with 100 pages, which is absolutely useless. Because, of course, you read them because it is part of the case. You have to be informed about this. But 100 pages to explain something about law, it's too much, isn't it? And it's unbearable, really unbearable. And sometimes,
and that's the worst thing that can happen. Do you want your arbitrator to read your brief and then say, "Oh my God, that was unbearable"?
I was discussing with my colleagues in a panel because I had there was a specific point about tax, and the professor who was the author of the legal opinion begins his opinion describing the history of that specific tax, that specific fee. So what the purpose of doing this with 100 pages? But of course, this is a good tip. Write as much as is necessary, but remember that someone else is going to read, and there must be some pleasure involved in this work. This is very important. But we are very curious about your life. How do you divide your tasks, professional and non-professional tasks? How do you share your time? Tell us about your routine, your daily routine.
Oh, but that there was a routine. We talked a little bit earlier about mentors, and I remember my mother telling me at one point, I think she had been invited to speak at a conference, and she'd been asked to talk about work-life balance and how to manage her role in the firm as well as her roles outside the firm. And she said to me, I think the concept of work-life balance is a bit of a misnomer. I'm not exactly sure that such a thing truly exists, because what you really do is that in any given moment, in any given situation, you decide what is most important, and that's what you prioritize. And so I think one will never be in a situation where there are no conflicts between things you want to do outside the firm, your family, your children, your parents, travel plans, vacation, and work. Those things will always clash on the borders. And I think in any given moment, you make an educated decision about what you need to prioritize. So I think the examples that I've given elsewhere is, if my child breaks their arm at school, it doesn't matter what's happening in the firm. I'm going to be in my car and I'm going to be on my way to the hospital immediately. There's no question. And I think then, if there's a client crisis or a hearing, a really important appearance, client meeting, then I will try and prioritize that. I do think that you can help yourself by being really honest and open with people about your schedule and setting limits where you can. I do think the pandemic has opened a door for us to be a little bit more open about the other things that are going on in our lives. We've had so many calls where people have seen our loved ones in the background, and so it's easy, I think, now to say, actually, at the time you're proposing for the call tomorrow, I have a pediatrician appointment with my daughter. I could do either earlier or later. And I think being transparent about the fact that instead of saying, oh, I have another thing at that time, I think it's actually more helpful and more human to give a real context to what it is that is creating the clash in your schedule. And I think that people are very understanding of those things, perhaps now more than ever. I do think that you have to learn how to prioritize things in a way that if you can have a sort of system as to how you prioritize things, I think that helps you correctly allocate your time in advance. So, I mean, I have a few things that I generally try to look at. So first of all, is the thing that I need to do revenue generating? So is it something actually that is important for generating revenue for the firm and doing the work I need to do for my clients? Is it important to my health? So, you know, those things that sometimes don't always have immediate deadlines, but you realize you haven't been to the dentist in 6 months. I think actually putting them high on the list because they're important to your health is critical. And I would put things like, you know, regular exercise and eating healthily. You know, again, too much takeout in the office is never a good thing. So I actually think prioritizing our own well-being and health is really important. I think you have to know how urgent things are. You have to know whether you can delegate it. And if you can delegate it, then, you know, you have to give yourself time to make sure you're able to delegate it and do it in a way that where you're going to give yourself time to review it when it comes back. And another thing I think is always to ask yourself, you know, do I have the information that I need in order to do this thing? There's nothing that actually annoys me more when I finally get around to doing something that I said that I would do, and I realize I still need input from other people in order to be able to attack it. And so actually, you know, I generally at the beginning of every day go through my task list and determine which of course, you know, there's always some things left over from yesterday and the day before. So I go to my task list and make sure it's up to date for that day. There's probably been some emails overnight that have added to my task list in some way. And I go through them very quickly and I say, can I delegate this? If so, to whom? I'll do that quickly so it gets off my plate and it gets moving in parallel. And then I work out, I just have a simple numbering system, 1, 2, 3, 4, 5, 6, 7 as to priority. What's the order in which I'm going to attack these things today? And I was once given some really important advice. I actually got an executive coach at one point in my career when I joined DLA Piper. And that person said, of your to-do list, you should only ever have 3 must-do things per day. Literally things that if they don't get done, the sky will fall in. And there's a couple of reasons for that. First of all, we always overestimate what we will actually get done. So we'll have a list of 10 things and we'll only get to 7. And then you feel like you haven't accomplished the things you should have accomplished. And that doesn't make you feel good about your day, even though you actually got 7 really important things done. So even psychologically, limiting it to 3 things that absolutely had to be done today can help you walk away from your day thinking, you know what, I did what I needed to do. But also, I think we have to be a little bit realistic about what we can get done in a day. Sometimes I think we pile things upon ourselves and then we get to the end of the day and we see so much slippage that it's a little bit downheartening. So I think we have to look after ourselves a little bit. That would be my big takeaway.
I want to talk to this coach. This must be a fantastic coach.
She was.
She
is. Yes.
You know, I am a stamp collector and I love reading historical novels. When I'm very nervous, I look at my stamps or I'll fly away from this world reading my books. What about your hobbies?
So I am a reader, definitely. And I have a range of books that I'm tackling at any one time. And when I have particularly anxious moments, I do find that going and getting a coffee and sitting down and reading and maybe a couple of pages of a very, relaxing novel can really calm me. And then I come back and I look at the problem and I have a much, more refreshed view of things. So I am also, I like various forms of exercise. I run, I swim, I play golf, I do yoga. And so I try to do something each day. And then on the weekends, I actually have quite a few things that I do. Normally I live in Mexico City, but on the weekends we try and get out of the city. And we have a place that has like a sporting complex around it. So, we play tennis, we play golf, there's horse riding even. I used to ride horses when I was little and I recently took it up again during the pandemic. I have to say, I don't think I'm quite as skilled as I was. But I love anything that gets me outdoors, to be honest.
Well, Kate, it was a real pleasure being with you this afternoon. But guys, time to say goodbye. So, Fabi?
Thank you so much. It is, for me as a female as well, it's great to have you as a role model. I really enjoyed our interview, and well, thank you.
The pleasure has been mine. Thank you so much. And I would be happy to answer, if anyone of your audience ever had a question that they wanted to ask me, they're welcome to send me an email. I'm always happy to answer questions and be helpful.
João?
Well, okay, thank you so much. And I look forward to having you in Brazil next month. So it would be really good to see you in the Brazilian Center of Arbitration Mediation in Rio de Janeiro. So for those that will be there, hope to see you and all of them in a bit. And thank
I'm
you so
looking
much.
forward to it as well. Bye-bye.
Gustavo?
Okay, to have just one word to say, fantastic. Thank you so much. It was really, really good. I appreciate your time and kindness to us. Thank you.
Thank you again for the invitation.
Thanks, Kate. Look forward to seeing you in Brazil as soon as possible. Bye-bye.